Good evening. This is John Milburn for Laws 11046. This is Law in the Environment. We're into week 10, and this week we're dealing with environmental prosecutions. One thing that you would have noticed in your reading so far, and what we've discussed, is that there are many ways to achieve a particular result. So if you are engaged to assist in a prosecution for a regulatory authority, or if you're asked to defend when someone is being challenged in relation to potential criminality, bear in mind that it's not just a matter of dealing with prosecutions and that there are wider issues. It may be that an administrative notice may suffice, or it may be that some sort of negotiated arrangement through civil action would be a substitute for criminal prosecutions. Usually these things are done through a lawyer, and prosecutors need to be very careful that if they are engaging directly with a defendant or a potential defendant, that they don't inadvertently offer an inducement or some sort of reward for a plea of guilty. Likewise, a defendant needs to be careful that they're not seen as if they were offering a bribe or some sort of inducement for the prosecutor to withdraw the charge. I mean, when I say bribe, I mean in a very general sense of offering to provide some sort of payment in lieu of a prosecution. But usually these things are done through lawyers, and in that context, these are generally regarded as useful and necessary parts of the negotiation. If, however, the situation is such that a criminal prosecution is necessary, then I guess one of the first things to do is consider the classification of the offence. In other words, some offences are summary offences and others are indictable offences. In simple terms, and this is very simplistic, a summary offence is a matter that is dealt with in the magistrate's court summarily, meaning before a magistrate, which would mean no jury. An indictable offence is one that is capable of presentation of an indictment. An indictment is a piece of paper presented by a prosecutor in the higher courts, which essentially kickstarts the litigation in the higher court. In order to proceed from the first mention of any offence, which is in the magistrate's court, to the higher courts, lawyers will engage in a number of different procedures, but probably these days the most common procedure is a committal, but a particular type of committal called a hand-up committal, which is where the prosecutor essentially hands up statements to a magistrate, and the magistrate then receives that material, but before reading the material, the defence lawyer offers to say that there's sufficient evidence to warrant the matter going to the superior court, the district or supreme court typically in state jurisdiction, and the lawyer says that there is sufficient material that a jury could essentially find that person guilty. Not a concession that it's a plea of guilty, not a concession that a jury would find them guilty, but a concession that a reasonable jury, properly instructed, could potentially find the defendant guilty. So that's the way we get it from the magistrate's court to the higher court so that it can proceed by way of indictment. But you need to, not every offence is one that is capable of having an indictment presented. So you need to understand the difference between summary and indictable, and then look to the legislation for guidance as to what it is. So in your notes, you would have seen some comments about classification of offences, and where it's an indictable offence and it goes to the higher court, that generally means that a jury determines the guilt or innocence as a determination of fact. That's under the legal supervision of a judge, as opposed to a summary offence where a magistrate decides both questions of law and questions of fact. So it's pretty obvious that, generally speaking, the more serious offences are indictable offences and the less serious offences are summary offences. But don't be fooled, as you would have seen in the notes, magistrates imposing penalties for environmental offences can sometimes impose very substantial penalties, and you would have seen examples of that So simply to say that it's summary and therefore not particularly important is far too simplistic. And likewise, not all indictable offences carry particularly serious penalties. However, I was talking about the classification of offences and the distinction between the summary and the indictable. So one thing you can consider is having a look at the legislation. So have a look at, for example, the Environmental Protection Act, and we'll have a look at that now. I'll just share the screen, if you can bear with me while I go through that process. I tend to favour OSCLE, but there are many different ways to get to the legislation. So OSCLE, Queensland legislation, Queensland Acts, Environmental Protection Act, and if we look at section 16 and 17, we'll see an example of how these different offences can be categorised. So the extent of harm can sometimes be an issue that is worthy of consideration. So here we have section 16, material environmental harm, and there's a definition of what that means, as opposed to the next section, which deals with serious environmental harm. And you'll see the threshold amount is $50,000 there, whereas in the previous one, the threshold amount is $5,000. So that's an example of where you need to consider the wording. And one of the things that defence lawyers do is try to negotiate down so that if the prosecutor initiates proceedings alleging, for example, serious environmental harm, we try to work around that piece of legislation to properly categorise it and encourage the prosecution at material environmental harm. That normally carries with it an obligation to plead guilty to the lesser charge. Usually, if it's a contested matter, prosecution are far less likely to negotiate. The other thing that you might consider in that context of the Environmental Protection Act is section 494. So we'll go back to the table, we'll go down to section 494, and I'll get there eventually. And I'm sure there's a much quicker way of doing it than the way I do, which is scrolling down. And you'll see that when it comes to legal proceedings, the Act itself prescribes the difference between indictable and summary offences, and that's in 494. So an offence against the Act for which the maximum penalty of imprisonment is 2 years or more is an indictable offence. And even then, indictable offences are broken into crimes and misdemeanours, but they're both indictable offences as opposed to anything else, which is a summary offence. So you must be aware of section 494 in the context of prosecutions involving the Vegetation Management Act or the Environmental Protection Act in this case. Now, every proceeding for an offence against the Vegetation Management Act must be taken summarily. So one thing you can sometimes do in negotiation is try to categorise the particular offending behaviour under a different piece of legislation. So it may be that you say, well, instead of prosecuting under the Environmental Protection Act, perhaps this is something that is more appropriately prosecuted under the Vegetation Management Act. And you need to have a working knowledge of those things. Okay, so that's the initial prosecution phase, if I can use that term. Now, I'm sure I can share this screen again, if you can bear with me. I'm not sure why things are moving around on my screen here. You can't see what's happening on my other screen, but I'm just having trouble in finding. Here we go. Sorry. You'd think I'd be all over this now. All right, defences. So If you're prosecuting or if you're defending, you need to be considering potential defences. I mean, you might ask, why would a prosecutor bother about typical defences? Well, there are two reasons. The first is that a prosecutor isn't going to embark on prosecution knowing that there's a defence that is likely going to succeed. And the other thing is that a prosecutor has a special onus. A prosecutor is what we call a model litigant. Model litigant, meaning that they must be a model of exemplary behaviour, if I can use that term. What that means is that they must provide all relevant information for consideration through the court system, and that means sometimes including material that is not necessarily consistent with their case theory. In other words, their case theory of guilt. It may be that there is some evidence that they come across which is exculpatory, meaning it helps the defence. They should provide that to defence. They should provide that as part of their prosecution, in that they're not just there to secure a prosecution. As a model litigant, prosecutors are there to ensure that there is a just outcome and an appropriate outcome. That means presenting the evidence, good and bad. So if you're a defence counsel, what you're really looking for is this. In part, you're looking to categorise the offence. You're looking to see if there are other offences where you could manoeuvre. You're looking for different ways that you can minimise and downgrade. We've talked about all those things. But I guess even before you do that, or in conjunction with doing that, you're thinking of ways to get your client off the charge. And one of the sections that you need to look at is in the Criminal Code, it's section 24, honest and reasonable mistake of fact. And I will share the screen once again. We'll have a look at the Criminal Code. You should see my screen now. Is that correct? We'll have a look at the Index C Criminal Code. Now, it's not the Criminal Code Act, it's the Criminal Code. And section 24 is the first one. Now, you'll see here that Chapter 5 deals with criminal responsibility. So there's a few defences in there. The first one is section 24, mistake of fact. So a person who does or omits to do an act under an honest and reasonable but mistaken belief in the existence of any state of things is not criminally responsible for the act or omission to any greater extent than if the real state of things had been such as the person believed to exist. So it may be that part of your argument is, look, made a mistake, but it was an honest and reasonable mistake, and therefore not criminally liable. Might be liable civilly, because that's a different test, but bear in mind that the prosecutor needs to establish beyond reasonable doubt, which is a very high, not impossible, but very high onus. So that's one possible defence that may be available. The next one is an emergency, something that's outside the control of the offender, section 25. So you need to have a look at that, because that may provide some sort of defence. Now, it's not just under the Criminal Code where defences might apply in environmental prosecutions. There may be some defences that are available under the specific legislation in question. Let's go back to the Environmental Protection Act and have a look at section 319. Section 319 provides that a person has a general environmental duty. So where a person attempts to show that the harm occurred while lawfully conducting an activity, and in doing so fulfil their general environmental duty, that may be a defence which is available against a prosecution. Another one, if we go back to the table, is found in section 493. And section 493 of the Environmental Protection Act provides that executive officers attempting to demonstrate that they took reasonable steps to prevent environmental harm may have a defence. So, in other words, the mere fact that there was environmental harm caused does not necessarily mean that there will be a successful prosecution. The executive officers might demonstrate they took reasonable steps to prevent the environmental harm. While I've got the legislation up, I'll just also draw your attention to this, not as a defence, but going back to my original comment that you need to be light on your feet, if I can use that term, in thinking of alternate ways to deal with a potential prosecution. And please excuse that I'm really putting on my defence hat here more than anything else. And I'm trying to get to the Sustainable Planning Act. Section 439 of the Sustainable Planning Act provides for contempt and contravention orders. So it may be, and I guess really this is more a prosecutorial issue, but it may be that if there is an existing order in place, proceeding not as criminal proceedings but as contempt proceedings under Section 439 of the Sustainable Planning Act is the way to go. Just stop the share now. So if there are any questions, please feel free to unmute your microphones, ask a question, use the chat facility. But what I've attempted to do so far is to say, I guess in simple terms, don't necessarily accept that what is there is the only way that things can happen. And whether you're prosecuting, whether you're defending, you need to think of these different alternatives. And if there is a prosecution, you need to think of different remedies or different ways of dealing with the situation. It's not just a simple matter of saying, well, we're pleading guilty or we're pleading not guilty. There are grey areas, there are different techniques that can be used where you can work around different sections of the Act or acts, as we've seen, in order to deal with issues. Now, what happens if you're stuck? And I'm talking about a defence situation where the court finds you guilty after a trial or your client pleads guilty. What can you do in accordance with the law to attempt to minimise the damage, so to speak? Well, the first thing is that there is much that can be done in planning and preparing for a sentence. And it's often overlooked. And, you know, people will say to me, well, if it's a plea of guilty, what do? Just turn up and say sorry. Well, usually there's a lot more that you can do than that. I mean, to take an example of someone that's addicted to drugs and they're charged with multiple burglary charges, leading up to a sentence hearing, the sorts of things that you can do is say, well, look, let's take remedial action. The court may say, well, part of this issue in sentencing you is whether you acknowledge that you've got a problem with drugs, and the second part is, are you prepared to do something about it? So it may be that a client will be in a much better position in terms of the sentence that is handed down if they have accepted their shortcomings and done something about it. Maybe they've gone into rehabilitation. So that's just a general example to highlight the point that you can do things leading up to a sentence that will affect the sentence in a good way, and I'm talking now from a defence perspective. So when it comes to environmental prosecutions, you must really put on your thinking cap, be light on your feet, come up with options that you might be able to work with your client to ultimately present to a court in terms of minimising the potential sentence and the potential damage. If you offer things, if you do things, if you facilitate things, then that will generally help. But let's have a look at sentencing guidelines generally. And while there is a difference in the guidelines between the state and the federal prosecutions, I'm just going to show you the state guidelines, which are found in the Penalties and Sentences Act. The Commonwealth has similar guidelines, and you can look in the Crimes Act in that regard. I'm just going to, once again, share the screen and take you to the State Penalties and Sentences Act. And it is here, 1992. The court needs to consider matters in determining the offender's character. It also needs to think about things like whether to record a conviction or not. But probably the main thing to take from the Penalties and Sentences Act is Section 9, which deals with sentencing guidelines. And this is where, when I'm defending a client, I will actually have that section typed or printed. And as I'm going through speaking to the client, I'm trying to highlight things that will work for the benefit of the client. And that gives me an angle, if I can use that term, and I don't mean it in a deceitful manner, but an angle to approach the defence and minimise the damage. So it may be by highlighting certain things, such as this, that the purpose of sentencing is to impose a sentence to punish to an extent that is just in all the circumstances. So it may be that part of your angle, part of your approach in dealing with the court is to look at that phrase and try to use it to your client's advantage. Of course, if you're a prosecutor, you may well be doing it from a different perspective. You might also look at other factors which are relevant in this particular case. So it may be to protect the Queensland community from the offender. And you might, in dealing with environmental prosecution, say, excuse me, sorry, you might say, well, this particular person is not a threat to the Queensland community for these reasons, and highlight those reasons. And bear in mind that when sentencing an offender, the court must have regard to a number of different things, and you can go through that list and try and identify things that are particularly relevant in this case. So any damage, loss or injury caused by the offender's character, age and intellectual capacity. And you might think, well, my client, if you're on the defence, is a person of very good character. And how would you prove that? By providing documentary evidence from other people or from documents that have been created in the past to show that your client does have good character. And you can say that is a relevant factor that the court must consider in this case. So that's just one example, for example, in this instance. All right, well, I'll leave you to have a look at Section 9 and generally have a look at the Penalties and Sentences Act of 1992 in that regard. So when you're thinking about issues to do with the Environmental Protection Act and prosecutions in that regard, also bear in mind, and I'll go back to the Act now, that there are two separate types of causation. And I'm just going to the Act now, and I'll share the screen. This is the last time, in case your head is starting to spin with all the share screen business. I'd like you to have a look at Section 437, and that's 4371 and 4372. So 4371, as we talked about before, serious environmental harm, but we did that in a different context. And they're the maximum penalty units, and you'll see the 5 years imprisonment. And you'll remember that that has something to do with determining whether it's indictable or not. And Section 4371 says a person must not willfully and unlawfully cause serious environmental harm. So when you're looking at a section like that, you might want to focus on a couple of words. Willfully, unlawfully, serious are probably words that stand out to me. And maybe give some thought to how you can argue for or against, depending on whether you're in prosecution or defence. If we look at the next section, subsection 2, it says a person must not unlawfully cause serious environmental harm. And you'll see there's 4,500 penalty units, as opposed to 6,250. The distinction there is quite clearly whether the charge number 1 is more serious, because there is the element of willfully causing as opposed to simply unlawfully causing the environmental harm. So you need to think about whether there is that issue relevant in your particular case. Also, in the Environmental Protection Act, if you're prosecuting or if you're defending, bear in mind, as I said from the outset, that there are other issues, such as civil issues, that may be relevant. And there is legislative effect in the Act through Section 24 of the Environmental Protection Act, which says the Act does not limit any civil right or remedy that exists apart from the Act, whether at common law or otherwise. So it may be that the imposition of a penalty for criminal action upon an environmental offender does not preclude a person from pursuing civil remedy for damages. In other words, the prosecution can occur, and in addition, the offender can be subject to civil rights and remedies as well. So if you're negotiating as defence counsel with the prosecutor, maybe you try to encourage a withdrawal of the criminal prosecution if you can provide some assistance in relation to civil issues, or perhaps vice versa. All right, thank you for your patience tonight. I hope that I haven't got your head spinning too much with those issues. The sections that I've been through tonight, in my view, are the main sections that you need to consider when it comes to dealing with state prosecutions for environmental offences, either from the perspective of the prosecutor or the perspective of an advisor for defence. Unless there are any queries, what I propose to do is post the answers in relation to the weekly problems in Moodle and call it a night for tonight. So are there any issues before I close the broadcast? We're all good? Yes? Okay. All right. Well, thank you very much. I'll stop the recording now and we'll see you next week.